Before we begin, a quick and important disclaimer. This program is presented strictly for educational and entertainment purposes. The historical accounts, case studies, and legal evolutions discussed herein do not constitute legal advice, financial counsel, or professional solicitation. Laws regarding domestic relations, asset division, and child custody vary significantly by jurisdiction and are subject to frequent legislative changes. Viewers should not act or refrain from acting based on any information presented in this documentary without seeking the appropriate legal counsel from a licensed attorney in their specific state or region. The complexities of family law require individualized attention, and the historical trends mentioned do not suggest specific potential outcomes for any personal legal matter. Please conduct your own due diligence and consult with a qualified professional regarding your unique situation. In the early morning mist of 1931, a steam engine pulled into a small station in Reno, Nevada. As the doors opened, a group of well-dressed men and women stepped onto the platform, not for a vacation or a business venture, but to participate in what was then known as the Reno Cure. At a time when the rest of the United States viewed divorce as a moral failing punishable by social exile and legal ruin, this small desert town had transformed the dissolution of marriage into a high-stakes industry. Behind every one of these travelers was a figure who would spend the next century moving from the shadows of the legal world to the very center of American power: the divorce lawyer. Today, we often view the end of a marriage as a standard, albeit painful, bureaucratic process involving the division of 401ks and the scheduling of weekend visits. But a century ago, the divorce lawyer was a social pariah, a legal combatant operating in a world of private investigators, staged hotel room raids, and the tactical use of scandal as a weapon. Statistically, the transformation is staggering. In the year 1900, the divorce rate in the United States was roughly 0.7 per 1,000 people. By the late 20th century, that number had surged, creating a legal sector that now influences over $50 billion in economic activity annually. But this documentary is not just a collection of statistics or a timeline of legislation. This is a deep dive into how the legal profession re-engineered the American family. We are going to explore how the divorce lawyer evolved from a scavenger of broken homes into a sophisticated architect of modern property rights and social policy. We will examine the era of fault-based litigation where lawyers had to prove adultery or cruelty to win a case, the rise of the celebrity superlawyer who turned the private lives of Hollywood stars into public battlegrounds, and the seismic shift toward no-fault divorce that changed the financial landscape for every American household. For the modern viewer, understanding this history is not just an academic exercise. It is a masterclass in the levers of the U.S. legal system. Whether you are interested in the protection of personal assets, the evolution of gender roles in the courtroom, or the way the law adapts to changing social mores, this story provides the blueprint. We are solving the mystery of why the American legal system handles the family unit the way it does today. By the end of this 10-part series, you will understand the strategic maneuvers that have defined a century of litigation, the historical trends that predict future legal shifts, and the profound way the divorce lawyer has shaped the concept of the American dream. To truly understand where we are, we must go back to the beginning of the 20th century, a time when getting a divorce was essentially a trial for a crime. In the early 1900s, most states operated under a strict fault-based system. To end a marriage, one party had to prove that the other was guilty of a specific legal wrong, such as desertion, extreme cruelty, or adultery. This created a paradoxical environment for the legal profession. Lawyers were not just advocates, they were directors of a theatrical performance. In New York, for instance, adultery was the only ground for divorce for decades. This led to the rise of the professional witness and the staged raid. Lawyers would hire private investigators to follow spouses, and in many cases, couples who both wanted to end the marriage would actually collaborate with their attorneys to manufacture evidence of a crime that never happened. They would hire a woman to be found in a hotel room with the husband just long enough for a hired photographer to snap a picture. This era of collusion and scandal was the crucible in which the modern family law firm was forged. It required a specific type of legal mind, one that was comfortable navigating the tension between the letter of the law and the reality of human behavior. These early practitioners had to be masters of the Heart Bomb Acts, a set of laws that allowed people to sue for the loss of love or the breach of a promise to marry. The stakes were not just about who kept the house, they were about who kept their reputation. A divorce lawyer in 1925 was essentially a reputation manager, tasked with ensuring that their client emerged from the wreckage of a marriage without being branded a social criminal. We must also look at the economic shift that occurred as women began to enter the workforce and gain property rights. In the early part of the century, the divorce lawyer's primary tool was the alimony award, often referred to as meal ticket litigation. Because women were largely excluded from the professional world, the law viewed the husband's income as a lifelong obligation. Lawyers spent decades refining the arguments for permanent alimony, creating a body of case law that would eventually be challenged and dismantled during the mid-century feminist movement. We will see how these attorneys adapted to the shift from viewing a wife as a dependent to viewing her as an equal partner in a marital corporation. The Reno cure mentioned earlier was the first major disruption to this rigid system. Nevada realized that by lowering residency requirements and offering more liberal grounds for divorce, they could attract a wealthy clientele from the East Coast. This created the first true divorce colonies. Lawyers in Reno became some of the most specialized and wealthy practitioners in the country, creating a model for interstate legal competition that still echoes in how states today compete for favorable tax or business laws. It was here that the concept of the quickie divorce was born, a term that would dominate the headlines for the next 40 years. As we move through this century-long journey, we'll analyze specific case studies that changed the rules of engagement. We will look at how the 1969 signing of the Family Law Act in California by then-Governor Ronald Reagan, the first no-fault divorce law in the country, effectively put an end to the era of the staged hotel raid and replaced it with a new, equally complex battleground: the valuation of intangible assets. Suddenly, the divorce lawyer was no longer looking for a smoking gun. They were looking for the hidden value in a professional degree, the future earnings of a celebrity brand, or the complex distribution of a family-owned business. This documentary is your guide through that transformation. We are moving beyond the surface-level drama to look at the mechanics of the law. You will see how the profession transitioned from the divorce mills of the 1930s to the high-tech, data-driven litigation of the 2020s. We are going to explore the psychological toll on the practitioners themselves, the ethics of a profession that thrives on the dissolution of the social fabric, and the landmark decisions that ensured that the divorce lawyer would become a permanent and perhaps necessary fixture of American life. This is the story of how we stopped fighting over who was wrong and started fighting over who gets what, and how that shift changed everything about how we live, work, and love in the United States. Prepare for a deep dive into the archives of the American courtroom, where the most private moments of our lives meet the cold, hard reality of the law. This is a century of the divorce lawyer. To understand the foundational architecture of the American divorce industry, we have to look at the era of the fault-based system, a period that lasted roughly from the turn of the century until the late 1960s. Imagine if you are a successful businessman in 1926 Chicago named Arthur. Arthur has spent 15 years building a manufacturing firm, and his wife, Clara, has managed their social standing and household. They have reached a point of irreconcilable differences, a term that didn't legally exist yet. In 1926, the law did not care if Arthur and Clara were unhappy. The law cared who was to blame. For Arthur's lawyer, this presented a massive strategic hurdle. In the state of Illinois at that time, unless Arthur could prove that Clara had committed a specific legal sin, adultery, desertion for over 2 years, or extreme physical cruelty, a judge would simply refuse to grant the divorce. If Clara also wanted the divorce but neither had committed a sin, they were effectively trapped in a legal stalemate. This created the first great boom for the divorce lawyer, the engineering of evidence. Lawyers during this era became part investigator and part theatrical producer. Because the law required a guilty party and an innocent party, attorneys had to manufacture innocence. This led to the rise of what historians call the professional correspondent. A divorce lawyer would often maintain a Rolodex of individuals, often struggling actors or people in desperate financial straits, who would agree to be found in a compromising position with the client. The process was mechanical. The lawyer would arrange for the husband to check into a specific hotel. At a prearranged time, a woman would enter the room. Minutes later, the wife's lawyer, accompanied by a private investigator and a photographer, would burst through the door. This staged raid provided the visual evidence of adultery required by the court. It was a dark, calculated dance that every judge in the country knew was happening. Yet the legal framework demanded it continue. The cost of these maneuvers was astronomical, making divorce a luxury product for the American elite. A lawyer's bill in 1930 wasn't just for legal research, it was for the logistics of surveillance. Data from that era suggests that a contested divorce could cost the equivalent of a modern-day luxury vehicle, often draining the very assets the parties were fighting over. This era also saw the birth of the alienation of affections lawsuit, a high-stakes legal maneuver where a spouse could sue a third party for stealing their partner's love. Imagine if Arthur's wife, Clara, discovered he was seeing another woman. Her lawyer wouldn't just file for divorce. They would file a secondary suit against the other woman for damages to the marital estate. These cases were the tabloid fodder of the 1920s and 30s, involving long, drawn-out testimonies about secret letters, midnight rendezvous, and the quantified value of a spouse's affection. Step by step, the divorce lawyer had to build a case that survived the doctrine of recrimination. This was a brutal legal rule. If both parties were found to be at fault, the court would grant a divorce to neither. If Arthur proved Clara was cruel, but Clara proved Arthur had committed adultery, the law essentially said they deserved each other and forced them to remain married. This meant lawyers had to be incredibly careful. They had to ensure their client appeared as a saint while the opposition appeared as a villain. It wasn't about the equitable distribution of wealth, it was about the moral high ground. The lawyer who could most effectively smear the opposition's character was the one who won the largest alimony awards. The financial component of this era was dominated by the concept of permanent alimony. Since women were largely barred from high-level employment, the lawyer's primary goal was to secure a lifelong income stream for the wife, provided she was the innocent party. For the husband's lawyer, the goal was to prove the wife's unfitness or infidelity to terminate that obligation. Historical trends show that these alimony battles were not just about money, they were about control. A woman who received alimony often lived under the threat of losing it if she ever lived with another man, or behaved in a way that violated the social norms of the time. The divorce lawyer was essentially the enforcer of these post-marital behavior codes. As the 1940s arrived and the United States became more mobile, the legal profession pivoted to address the problem of jurisdiction. This is where the migratory divorce became a cornerstone of the industry. Because states like New York remained incredibly restrictive, lawyers began advising their wealthy clients to move to Nevada or Florida for the 6-week residency period. This created a massive legal conflict regarding the full faith and credit clause of the U.S. Constitution. Could a New York court ignore a Nevada divorce decree? Lawyers spent decades arguing this at the highest levels, eventually leading to landmark Supreme Court cases like Williams versus North Carolina. These cases established that as long as the residency was legitimate, other states had to recognize the divorce. This gave birth to the specialized travel lawyer, a professional who coordinated the client's move, their temporary housing in a Reno ranch, and their legal filing, all while managing the optics to ensure the New York courts wouldn't later declare the divorce a sham. Beyond the logistics of the decree, we must analyze the evolution of child custody during this period. For much of the early 20th century, the legal system operated under the tender years doctrine. This was the presumption that during a child's early years, the mother was naturally better suited for custody. However, this was not a guarantee. If a father's lawyer could prove the mother was morally unfit, usually by documenting an affair or even just non-traditional social behavior, the father would often be awarded sole custody as a form of punishment against the wife. The children were essentially treated as property that followed the innocent spouse. Divorce lawyers in the 1950s became experts in character assassination to win these custody battles, using everything from a mother's smoking habit to her choice of friends as evidence of her unfitness. By 1960, the pressure on this system was reaching a breaking point. The hypocrisy of staged raids and the high cost of migratory divorces created a massive divide between the wealthy who could afford an out-of-state escape and the middle class who remained trapped in dysfunctional or even dangerous marriages. Lawyers began to see that the fault-based system was not only ethically questionable, but also increasingly inefficient for a modernizing economy. The legal profession began to lobby for a system that focused on the reality of the relationship rather than the proof of a sin. But as the old guard of the legal world clung to the lucrative chaos of the fault era, a new movement was brewing in California that would eventually dismantle the entire structure. This shift would replace the private investigator with the forensic accountant and the photographer with the actuary. The battle was about to move from the bedroom to the boardroom, and the stakes were about to get much higher. If you think the era of the staged hotel raid was scandalous, wait until you see what happened when the law decided that nobody had to be at fault. How did the sudden shift to no-fault divorce in the late 60s create a trillion-dollar industry almost overnight? And why did this change lead to the rise of the first celebrity superlawyers, who would eventually represent the biggest names in Hollywood and Washington? The next part of this deep dive explores the radical transformation of the 1970s, where the divorce lawyer became the most feared person in the American financial landscape. The transition from the moralistic battlegrounds of the mid-20th century to the clinical, data-driven environment of the 1970s represents the single most significant pivot in the history of the American legal profession. On January 1, 1970, the Family Law Act of 1969 took effect in California. It was signed into law by Governor Ronald Reagan, who ironically was the first divorced man to hold the office of the presidency. This law introduced the concept of no-fault divorce to the United States, effectively ending the requirement that one spouse must prove the other had committed a legal wrong. Historical trends indicate that this was intended to reduce the perjury and staged evidence that had plagued the courts for decades, but the actual potential outcomes were far more complex. The divorce lawyer did not lose their job. They simply traded their detective's badge for a calculator. Imagine if you are a high-level executive in Los Angeles in 1972 named Robert. Under the old system, Robert's lawyer would have spent months investigating whether Robert or his wife, Susan, had a secret life. But under the no-fault system, the legal barrier to exit was removed. Robert could simply state that the marriage suffered from irreconcilable differences. However, this ease of filing triggered a new, more aggressive type of litigation. Because the court was no longer focused on who was at fault, the battle moved entirely into the realm of asset valuation. This gave birth to the era of forensic accounting. Robert's lawyer now had to hire experts to go through 15 years of tax returns, stock options, and pension contributions. For the first time, the legal profession began to treat a marriage not as a moral covenant, but as a corporate merger that was being dissolved. In this decade, we see the rise of the specialized expert witness. Step by step, the divorce process became a technical marathon. First, a lawyer would file the petition. Second, a mandatory discovery phase would begin, which in the 1970s became an exhaustive search for hidden wealth. Lawyers began to use tools like the request for production of documents to demand every bank statement, canceled check, and ledger. Third, they would hire actuaries to determine the present value of a future pension. If Robert had a pension that wouldn't pay out for 20 years, the lawyer had to argue what that was worth in 1972 dollars so Susan could get her share today. This transition turned the courtroom into an arena for economic theory rather than character judgment. Case studies from this era, specifically in California, show that the move to no-fault divorce led to an immediate and sharp increase in divorce filings. This was not necessarily because more marriages were failing, but because the legal choke point had been removed. This created a massive supply and demand problem. To handle the volume, the legal industry professionalized at an incredible rate. Law firms that once handled a variety of civil matters began to create dedicated family law departments. The divorce lawyer became a rainmaker, bringing in consistent, high-volume revenue for firms that were navigating the economic stagflation of the 1970s. We must also analyze the emergence of the community property versus equitable distribution divide. In states like California and Texas, the law dictated a strict 50-50 split of all assets acquired during the marriage. But in many other states, the doctrine of equitable distribution took hold. This was far more lucrative for lawyers because equitable does not mean equal. It means fair. If you are a lawyer in an equitable distribution state in 1975, you have a massive opportunity to argue that your client deserves 60%, 70%, or even more of the marital estate based on their contribution to the marriage. Lawyers began to craft sophisticated narratives about the non-monetary contributions of a homemaker or the career sacrifices one spouse made to put the other through medical school. The legal argument shifted from "my client is a saint" to "my client's labor created this wealth." One of the most seismic shifts of this decade was the 1976 case of Marvin versus Marvin. This introduced the world to the concept of palimony. Michelle Triola had lived with actor Lee Marvin for years without being married. When they split, her lawyer, the legendary Marvin Mitchelson, argued that there was an implied contract for financial support. Mitchelson was the archetype of the new celebrity divorce lawyer, flamboyant, media-savvy, and willing to push the boundaries of existing law. Although Triola eventually lost the financial award, the case established a historical trend. The law could now reach into non-marital relationships. For the divorce lawyer, this meant their potential client base had just expanded to include every cohabitating couple in America. The 1970s also saw a radical change in the language of the law. Terms like alimony were slowly replaced with maintenance or spousal support. The goal was to remove the stigma of a penalty and frame it as a transitional financial tool. However, for the lawyers on the ground, this was a distinction without a difference. They were still fighting for every dollar. By 1978, the introduction of the 401k and the subsequent passage of the Retirement Equity Act in the following years created a whole new category of assets to fight over. Lawyers had to become experts in ERISA law and qualified domestic relations orders, or QDROs. If you didn't have a lawyer who knew how to draft a QDRO, you could potentially lose access to half of your spouse's retirement savings due to a technicality. This era of the 1970s and early 1980s was also when the lawyer's role as a psychological gatekeeper became prominent. With the social guardrails of the past removed, clients were often more volatile. Lawyers began to realize that a high-conflict divorce was more profitable than a mediated one. This led to the criticism of the scorched earth policy, where attorneys would file motion after motion, not necessarily to win a specific point, but to exhaust the other party's financial and emotional resources. This was a tactical use of the legal system to force a settlement. We see this reflected in the data of the time, which shows the average length of a contested divorce increasing from months to years. As we look at the landscape in 1980, the American family had been fundamentally redefined by the legal profession. The divorce lawyer was no longer a shady character operating out of a dusty office. They were a high-powered consultant who influenced the flow of billions of dollars. They had successfully argued that a medical degree was a marital asset, that a pension was a joint property, and that even the lack of a marriage certificate didn't protect you from a lawsuit. But as the 1980s dawned, a new challenge emerged that would take the industry to a level of aggression and complexity that no one could have predicted. While the 70s were about the what, the 80s would become about the who. Specifically, the rise of the high-stakes custody battle in an era of dual-income households. When both parents are working, who gets the kids? And how did the legal profession turn the psychological well-being of a child into a weaponized expert testimony? If you think the fight over money was intense, the next part of our documentary reveals the chilling evolution of the 1980s custody wars. We will look at how the emergence of the best interests of the child standard gave lawyers almost unlimited power to psychoanalyze their opponents, leading to one of the most controversial eras in American legal history. What happens when the lawyer stops being an advocate and starts being a social engineer? The answer lies in the decade of excess. The 1980s arrived with a sharp, metallic edge that redefined the American courtroom. This was the decade of excess, where the greed is good mantra of Wall Street bled directly into the domestic relations court. If the 1970s were about the liberation of the individual through no-fault laws, the 1980s were about the commodification of the family. The divorce lawyer of this era evolved into a high-stakes strategist, navigating a landscape where the primary objective was no longer just the dissolution of a contract, but the total acquisition of assets and the weaponization of the new best interests of the child standard. This period marked the death of the tender years doctrine, which had previously presumed that mothers were the natural custodians of young children. In its place rose a subjective, complex, and highly litigious framework that allowed lawyers to turn a child's psychological profile into a centerpiece of legal combat. Imagine if you are David and Elena in 1985. David is a rising vice president at a mid-sized investment firm in New York, and Elena is a successful marketing director. They have 2 children, a brownstone in Brooklyn, and a summer home in the Hamptons. In 1955, Elena would have almost certainly received custody and a modest alimony check. But in 1985, the legal landscape has shifted under their feet. David's lawyer, a high-priced litigator with a penchant for psychological warfare, realizes that under the new best interest standard, custody is no longer a foregone conclusion. By challenging custody, David's lawyer creates a massive lever in the financial negotiations. The strategy is clear. If David threatens to take the children, Elena might be more willing to concede on the division of his rapidly appreciating stock options and the valuation of his partnership in the firm. This era saw the birth of a massive cottage industry of ancillary professionals. Step by step, the divorce lawyer began to build a team that looked more like a task force than a legal staff. First, the lawyer would move for the appointment of a guardian ad litem, an attorney specifically tasked with representing the children. While intended to be a neutral advocate, in the high-conflict 1980s, these guardians often became another variable for lawyers to influence. Second, the court would order a custody evaluation. This brought psychologists and social workers into the fray. These experts would spend months observing the family, conducting Rorschach tests, and interviewing teachers. For the divorce lawyer, the goal was to find an expert whose professional philosophy aligned with their client's goals. If Elena's lawyer knew a particular psychologist favored the primary caregiver, they would fight to have that specific expert appointed. Historical trends during this decade show a dramatic rise in the use of the scorched earth policy. This was a tactical approach where one party would file a relentless stream of motions, requests for temporary support, demands for the production of every receipt from the last 10 years, and emergency hearings over weekend visitation. The potential outcome was not necessarily a victory in court, but the financial and emotional exhaustion of the opponent. In our scenario with David and Elena, David's lawyer might demand a full audit of Elena's travel expenses from her marketing firm, suggesting that her career-related travel constitutes child neglect. This forced Elena to spend thousands of dollars in legal fees just to defend her professional life, creating a war of attrition that favored the spouse with deeper pockets. The financial complexity of the 1980s also introduced the concept of professional goodwill as a marital asset. This was one of the most significant legal expansions of the century. Lawyers began to argue that if a husband spent the marriage building a medical practice or a law firm, the reputation of that business, its goodwill, was a tangible asset that could be valued and divided. Case studies from this era, such as the landmark decisions in states like New Jersey and California, established that the increased earning capacity of a spouse was a product of the marital partnership. This meant that the divorce lawyer had to become a student of business valuation. They hired forensic accountants to apply the capitalization of excess earnings method to a doctor's private practice. They weren't just looking at the equipment in the office. They were calculating the projected value of the doctor's future patients over the next 20 years. This led to the 1984 Child Support Enforcement Act. As the legal battles grew more complex and the divorce rate climbed toward its historic peak, the federal government realized that many families were falling through the cracks of this high-cost litigation. The act required states to create more rigid, formulaic guidelines for child support, attempting to take some of the discretionary power away from the lawyers and judges. However, the divorce lawyer simply adapted. Instead of arguing over the amount of support, they began to argue over what constituted income. Does a corporate car allowance count as income? What about the unrealized growth in a 401k? Every new regulation provided a new frontier for legal interpretation. The 1980s was also the decade when the prenuptial agreement moved from the realm of European royalty into the American middle class. As the public watched high-profile divorces play out in the media, a sense of legal self-defense took hold. Lawyers began advising their clients to treat marriage like a pre-packaged liquidation plan. The drafting of these agreements became a specialized skill set. A lawyer had to ensure that the document was not only fair at the time of signing, but would remain enforceable 15 years later, under totally different economic circumstances. This was the beginning of the era of the protective lawyer, one who viewed the wedding day as the first step toward a potential courtroom battle. As we reached the end of the 1980s, the divorce lawyer had become a figure of both fascination and fear in American culture. They were the architects of a system that could dismantle a life with surgical precision. They had successfully turned the most intimate details of parenting and the most complex structures of corporate finance into billable hours. The average cost of a contested divorce had spiraled, creating a massive barrier to justice for those who could not afford the expert witnesses and the forensic audits. But just as the legal profession was mastering the art of the 1980s power divorce, a new force was gathering on the horizon. The 1990s would bring a technological revolution that would change the nature of evidence forever. The divorce lawyer was about to enter the world of the digital footprint, where a deleted email or a hidden hard drive could be more damaging than any staged hotel raid from the 1930s. How did the arrival of the internet and the first generation of mobile phones turn the divorce lawyer into a digital detective? And why did the 1990s see the rise of the first billion-dollar divorce settlements, forcing the legal system to rethink the very definition of wealth? The next part of our masterclass explores the era of digital discovery and the high-stakes world of the 90s megadivorce, where one single line of code could be worth $10 million. The 1990s brought a seismic shift to the American courtroom, a decade defined by the transition from the physical to the digital, and from the million-dollar settlement to the billion-dollar empire. This was the era of the dot-com boom, where wealth was no longer just found in real estate, gold, or manufacturing plants, but in lines of code and unvested stock options. For the divorce lawyer, the 1990s were the beginning of the digital forensics age, a period where a single deleted email or a hidden floppy disk could shift the potential outcomes of a 10-year litigation battle. The legal profession had to rapidly evolve to understand the mechanics of Silicon Valley, the intricacies of offshore banking, and the burgeoning concept of the marriage as a high-stakes corporate partnership. Imagine if you are Michael and Jennifer in 1997 Palo Alto. Michael is one of the early employees at a software startup that is months away from an initial public offering. His base salary is $80,000, but he holds options for 500,000 shares of stock. Jennifer has spent the last 5 years supporting the household, often working 2 jobs to cover their rent while Michael worked 20-hour days at the office. In the eyes of a 1950s lawyer, Jennifer might have been entitled to modest alimony based on Michael's $80,000 salary. But in 1997, the divorce lawyer had to become a financial architect. Michael's lawyer would argue that the stock options were a reward for future service and therefore separate property. Jennifer's lawyer, however, would present a sophisticated argument for marital effort. They would argue that because Michael worked on that code while married, the potential value of those shares was a marital asset, regardless of when they actually vested. This introduced the Moore-Marsden calculation and other complex formulas into the standard toolkit of the family law practitioner. Historical trends during this decade show that the definition of a marital asset expanded to include almost anything with future earning potential. We see this most clearly in the landmark case study of Wendt versus Wendt in 1997. Lorna Wendt, the wife of GE Capital CEO Gary Wendt, rejected a $20 million settlement offer, arguing that it did not reflect her 32-year contribution to her husband's career. Her legal team pioneered the partnership theory of marriage at the executive level. They argued that a corporate wife was a business partner who managed the social, domestic, and emotional infrastructure that allowed the CEO to thrive. This case was a turning point for the divorce lawyer, as it moved the conversation away from needs-based alimony toward a shared interest in the total marital estate. The court eventually awarded her approximately $20 million, but the legal precedent it set regarding the valuation of executive perks, country club memberships, corporate jet access, and deferred compensation changed the way every high-net-worth divorce was handled from that point forward. Step by step, the discovery process in the 1990s underwent a technical revolution. First, the standard request for production of documents expanded to include computer hard drives and backup tapes. Lawyers began hiring the first generation of digital forensic experts to recover deleted files. Second, the deposition changed. Lawyers weren't just asking about who spent what at the grocery store. They were asking for the passwords to private servers. Third, the valuation of intellectual property became a primary battlefield. If a spouse wrote a book, patented a device, or developed a software algorithm during the marriage, the lawyer had to hire an actuary to project the royalty income for the next 20 years. This required a level of mathematical and technical literacy that the previous generation of lawyers simply did not possess. The 1990s also witnessed the birth of the mega settlement, headlined by the 1999 divorce of Rupert and Anna Murdoch. With a settlement estimated at $1.7 billion, it signaled to the world that the divorce lawyer was now operating at the highest levels of global finance. This case highlighted the critical importance of the postnuptial agreement and the use of complex trusts to shield assets. Lawyers had to navigate the laws of multiple jurisdictions simultaneously, as assets were often spread across different states and countries. The divorce lawyer became a global strategist, coordinating with tax attorneys in the Cayman Islands and corporate counsel in London to untangle the web of a multinational marital estate. As we look at the data from the mid to late 90s, the cost of a contested divorce continued to skyrocket, driven by the need for these specialized experts. The potential outcomes for a client were increasingly dependent on the quality of their forensic team. This created a two-tiered system of justice. While the wealthy were fighting over the future value of tech stocks, the middle class was struggling with the first wave of the 401k era. The Retirement Equity Act of 1984 had made it possible to divide pensions, but the 1990s saw the 401k become the primary retirement vehicle for most Americans. Lawyers had to master the Qualified Domestic Relations Order, or QDRO, a highly technical legal instrument required to split a retirement account without triggering massive tax penalties. A single error in a QDRO could cost a client hundreds of thousands of dollars in future savings, making the divorce lawyer's role as a technical specialist more dangerous than ever. The end of the decade also saw the first hints of what would become the social media revolution. In the late 90s, early chat rooms and message boards became the new frontier for evidence of infidelity or hidden lifestyles. A lawyer in 1999 might spend hours printing out transcripts from an America Online chat room to prove a spouse was planning to move assets or was engaging in a hidden relationship. It was the beginning of the end of privacy in the divorce process. The digital footprint was becoming permanent, and the divorce lawyer was the one learning how to follow the trail. By the time the ball dropped on the new millennium, the divorce lawyer had successfully transformed from a courtroom orator into a data-driven litigator. They had integrated themselves into the world of venture capital, intellectual property, and digital surveillance. They had moved the needle on what it meant to be a partner in a marriage, ensuring that the labor of the home was increasingly recognized in the ledger of the law. But as the 2000s began, a new set of challenges was emerging. The dot-com bubble was about to burst, and the housing market was beginning a climb that would eventually lead to a global catastrophe. What happens to a divorce settlement when the assets everyone fought over suddenly disappear? How did the 2008 financial crisis rewrite the rules of alimony and asset division? And why did it lead to a surge in gray divorce among the older generation? The next part of our masterclass explores the era of the Great Recession and the rise of social media, where the divorce lawyer had to navigate a world of underwater mortgages and Facebook-fueled scandals. We are moving into the 21st century, where the stakes grew even higher as the economy began to crumble. The dawn of the new millennium brought with it a paradox that would redefine the divorce lawyer's role for the next 2 decades. On one hand, the United States was entering a period of unprecedented digital transparency, and on the other, it was hurtling toward a financial abyss that would turn the American dream of homeownership into a legal nightmare. By the year 2004, the divorce lawyer was no longer just looking at bank statements. They were looking at MySpace profiles and the newly launched Facebook. This was the birth of the social media evidence era, a historical trend that transformed the discovery process from a hunt for paper trails into a deep dive into the digital psyche. Imagine if you are Mark in 2006. Mark is a project manager in a mid-sized construction firm in Phoenix, Arizona. He and his wife Sarah have reached the end of their marriage. Mark tells his lawyer that he has no extracurricular income and that his lifestyle is modest. However, Sarah's lawyer has spent the weekend scouring the internet. They find photos Mark posted on a public forum showcasing a newly purchased, high-end motorcycle and a series of check-ins at expensive restaurants in Scottsdale. In the 1980s, Sarah would have needed a private investigator to follow Mark for weeks to gather this data. In 2006, her lawyer simply hit the print button. This era introduced the concept of the digital smoking gun. Divorce lawyers began adding social media clauses to their initial retainers, warning clients that every status update, every tagged photo, and every late-night comment could and would be used against them in a court of law. But the digital revolution was quickly overshadowed by the 2008 financial crisis. This was the moment the divorce industry faced its greatest challenge since the Great Depression. Historically, during economic downturns, the divorce rate tends to flatten or even dip, not because people are happier, but because they literally cannot afford to leave. In 2009, the divorce lawyer's primary task shifted from dividing assets to dividing debt. This was the era of the underwater mortgage divorce. Consider a case study involving a couple in Florida during the height of the Great Recession. They owned a home purchased in 2005 for $450,000. By 2010, the market had cratered, and the home was worth only $280,000, while the mortgage remained at $400,000. For the divorce lawyer, this was a mathematical and legal puzzle with no easy solution. Step by step, the lawyer had to navigate a process that had no precedent in the boom years. First, they had to determine who would stay in the home and take on the negative equity, or if a short sale was the only viable option. Second, the lawyer had to negotiate with the bank, not just the spouse, to see if a mortgage modification was possible in the middle of a dissolution. Third, they had to argue over who was responsible for the deficiency judgment if the house was sold at a loss. The divorce lawyer became a debt restructuring expert, often spending more time talking to loan servicers than to the opposing counsel. This financial strain also gave rise to the gray divorce phenomenon. Historical trends show that while divorce rates among younger demographics were stabilizing or falling, the rate for those over the age of 50 began to double. These were the silver splitters. These cases were uniquely complex because they involved the division of assets that were supposed to fund a shared retirement. Lawyers in this sector had to become experts in Social Security law, healthcare costs, and the long-term impact of dividing a fixed pension during an era of low interest rates. If you are a 60-year-old woman in 2011, your lawyer is no longer just fighting for a house. They are fighting for the right to remain on your ex-husband's insurance plan through COBRA or arguing for a larger share of the 401k because your re-entry into the workforce is statistically less likely to result in a high salary. The 2008 crisis also forced a radical rethinking of alimony, or spousal support. In the decades prior, alimony was often set based on a snapshot of the husband's peak earning years. When the economy collapsed and high-earning executives saw their bonuses vanish or their positions eliminated, the courts were flooded with modification suits. Lawyers had to argue the difference between a temporary setback and a permanent change in circumstances. This led to a legislative shift in many states toward durational alimony, ending the era of permanent, lifelong payments in favor of support that lasted for a specific number of years based on the length of the marriage. The divorce lawyer had to adapt to a world where the financial future was no longer predictable. By 2015, the legal landscape had settled into a new normal, but the tools of the trade were evolving again. This was the decade of the smartphone, and with it came the appification of divorce. Lawyers began using specialized software to track shared expenses, and apps like Our Family Wizard became court-mandated tools for high-conflict custody cases. The divorce lawyer was now a manager of digital communication, often reviewing thousands of text messages to prove a pattern of harassment or a violation of a parenting plan. The potential outcomes of a custody battle were increasingly determined by the metadata of a text message, proving exactly what time a parent arrived for a pickup and what tone they used in their digital correspondence. As we look back from the vantage point of 2026, we can see that the 2000s and 2010s were the period where the privacy of the American home was finally and completely dismantled by the legal system. Everything was recorded, everything was discoverable, and everything had a price tag. The divorce lawyer had transitioned from a courtroom litigator into a data scientist and a financial crisis manager. They were navigating a world where a person's entire life was stored on a cloud server, and the key to that server was the most valuable asset in the room. However, even as the legal profession mastered the art of digital discovery and debt division, a new disruption was quietly building in the background. It wasn't a financial crash or a new social network. It was the rise of the do-it-yourself movement and the emergence of artificial intelligence. The legal industry was about to face a challenge that didn't come from a rival firm or a disgruntled spouse, but from a line of code that claimed it could do a lawyer's job for a fraction of the cost. How did the rise of legal tech and DIY divorce platforms in the late 2010s threaten the century-old monopoly of the divorce lawyer? And what happened when the first AI-driven mediation tools began to outperform human attorneys in dividing complex estates? The next part of our deep dive explores the digital frontier of the 2020s, where the very existence of the traditional law firm was put to the test. We are entering the modern era, where the battle for the future of the family is being fought not just in the courtroom, but in the algorithm. The year is 2018, and the mahogany desks of traditional law firms are beginning to gather digital dust. For nearly a century, the divorce lawyer held a monopoly on the keys to the courthouse. If you wanted to dissolve a marriage, you had to pay the gatekeeper. But as the 2010s drew to a close, a new force emerged that threatened to turn this entire professional guild upside down: the commodification of the legal process. This was the era of the do-it-yourself revolution, where startups like Hello Divorce and platforms like LegalZoom began to realize that about 70% of divorces are technically uncontested. These companies bet on the idea that many Americans didn't need a $300 an hour gladiator. They needed a user-friendly interface. Imagine if you are James and Chloe in 2019. They have been married for 7 years, they have no children, and they have already agreed on how to split their modest savings and their Toyota Camry. In 1999, their lawyer would have charged them a $5,000 retainer just to handle the paperwork, navigate the clerk's office, and ensure the service of process followed the strict letter of the law. In 2019, James and Chloe sit at their kitchen table with a laptop. They use a guided platform that asks them a series of intuitive questions, generates the necessary state-specific forms, and provides a step-by-step checklist for filing. For a flat fee of less than $500, the technology has replaced the junior associate. This shift represented the first real crack in the financial foundation of the family law firm. Historical trends show that as these platforms gain traction, the volume of pro-se filings, individuals representing themselves, surged in family courts across the United States. However, the real disruption wasn't just in the paperwork, it was in the decision-making. By 2021, the legal industry began to witness the rise of AI-driven mediation. This wasn't just a digital form, It was an algorithm capable of processing thousands of past judicial decisions to predict potential outcomes. Consider a case study involving a couple with a complex estate worth $2 million, including a primary residence, two 401ks, and a small collection of cryptocurrency. In a traditional setting, two opposing lawyers would spend 18 months and $50,000 in fees arguing over the equitable distribution of these assets. Each lawyer would take a position, file motions, and eventually settle on the courthouse steps. Enter the AI mediator. The couple inputs their financial data into a secure platform. The algorithm, trained on a decade of local court rulings and tax codes, analyzes the tax implications of liquidating the crypto versus transferring the 401k via a QDRO. Within 48 hours, the system generates 3 different distribution models that it deems equitable under state law. It doesn't have an ego, it doesn't get tired, and it doesn't bill by the minute. For the divorce lawyer, this was an existential threat. The profession had to decide, do we fight the machine or do we learn to pilot it? Then came the spring of 2020. The global pandemic did in 3 months what the legal tech industry had been trying to do for 10 years. It forced the American court system into the 21st century. Almost overnight, the physical courtroom drama, the whispered huddles in the hallway, the dramatic reveals on the witness stand, was replaced by a grid of faces on a Zoom call. This was a catastrophic blow to the old-school litigator, who relied on physical presence and courtroom theater. Step by step, the divorce lawyer had to re-engineer their entire practice. First, they had to master digital evidence management as paper exhibits became obsolete. Second, they had to learn the art of the virtual deposition, where reading a witness's body language through a grainy webcam became a vital skill. Third, they had to navigate the Zoom divorce backlog. With courts closed to all but emergency matters, the wait times for a trial date exploded from months to years. This backlog created a massive surge in the demand for private judging and alternative dispute resolution. If you couldn't get a court date until 2023, you hired a retired judge to hear your case in a conference room. The divorce lawyer's role shifted from being a combatant in a public arena to being a negotiator in a private one. The potential outcomes of these private sessions were often more creative and flexible than what a state judge could provide, leading to a historical trend of collaborative divorce. In this model, both parties and their lawyers sign a contract agreeing not to go to court. If the process fails, the lawyers must resign, and the parties start over with new counsel. This created a powerful financial incentive for the lawyers to actually resolve the conflict rather than escalate it. By 2024, the data showed a clear bifurcation in the industry. On one side was the low-cost, automated world of uncontested, tech-driven divorce. On the other was the high-touch, ultra-specialized world of the legal engineer. This new breed of divorce lawyer in 2026 doesn't just know the law. They understand the psychological and technological architecture of the modern family. They are part therapist, part financial strategist, and part tech consultant. They are the ones handling the digital asset divorces, where the primary battle isn't over the house, but over the login credentials to a YouTube channel with 3 million subscribers, or the intellectual property of a viral TikTok brand. Imagine if you are a high-profile influencer in 2026. Your brand is worth $5 million, but that value is tied entirely to your face and your daily content. If you divorce, is your spouse entitled to half of the future revenue of your digital persona? This is the new frontier where the algorithm meets the law. The lawyer of today must argue the valuation of personal goodwill. In the age of the creator economy, they are no longer just looking at bank ledgers. They are looking at engagement metrics, brand longevity projections, and the potential impact of a public scandal on the marital estate's value. The divorce lawyer has survived a century of upheaval by being the ultimate chameleon. They survived the end of the fault-based era, they mastered the forensic accounting of the 80s, they navigated the digital discovery of the 90s, and they managed the financial ruin of the 2000s. Now, in the late 2020s, they are pivoting again. They are moving away from the scorched earth tactics of the past and toward a more holistic, data-driven approach to family restructuring. They have realized that in a world where an AI can do the math, the human lawyer's value lies in their ability to manage the human heart and the strategic complexities that a machine cannot yet grasp. But as the legal profession finds its footing in this high-tech landscape, a new and deeply controversial question is beginning to surface. If we can use AI to divide assets and calculate support, should we also use it to determine the fate of children? We are on the verge of a revolution in the most sensitive area of family law, the automated custody evaluation. Can an algorithm truly determine the best interests of the child? And what happens when a parent's entire life, their heart rate, their location, their social interactions, is tracked by wearable tech and used as evidence in a custody battle? The next part of our masterclass dives into the biometric divorce and the ethical minefield of 21st century parenting litigation. How did the rise of the Internet of Things turn every home into a surveillance state for the divorce lawyer? The answer will change everything you thought you knew about privacy, parenting, and the power of the law. In this current year of 2026, the sanctuary of the American home has been replaced by a network of silent, digital witnesses that never sleep and never forget. This is the era of the biometric divorce, a phase of legal history where the Internet of Things has effectively turned every household object into a potential informant for a divorce lawyer. If the 1990s were about the digital footprint of an email, and the 2010s were about the public exposure of social media, the mid-2020s are about the biological and environmental record of our very existence. The divorce lawyer has evolved once again, moving from a forensic accountant to a data architect who specializes in the interpretation of physiological and locational metadata. Imagine if you are a father named John in a high-stakes custody battle in 2026. John considers himself an attentive parent, but his ex-wife's lawyer is about to use his own home against him. Step by step, the lawyer initiates a process that would have seemed like science fiction a generation ago. First, they file a motion for the preservation of all cloud-based data from the marital residence. This includes the logs from the smart refrigerator, the history of the smart locks, and the recordings from every voice-activated assistant in the house. Second, they subpoena the data from John's high-end fitness tracker and his smart bed. Third, they hire a data forensic specialist to correlate these data points. The potential outcomes of this analysis are devastating for John's case. The lawyer presents a report showing that while John claimed to be home caring for the children every Tuesday night, his smart lock never registered an entry until 11 p.m. Furthermore, his fitness tracker showed an elevated heart rate and high physical activity in a location 10 miles away from his home during those hours. The smart bed data reveals that his sleep cycles were erratic, suggesting a level of exhaustion that the lawyer argues makes him an unfit primary caregiver for an infant. Historical trends show that the best interests of the child standard was once a subjective evaluation performed by a social worker. Today, it is increasingly becoming a math equation derived from a server log. This transformation has fundamentally changed the discovery phase of a U.S. divorce. We must analyze the shift from character witnesses to biometric evidence. In 1950, a lawyer would call a neighbor to testify that they saw John coming home late. In 2026, the neighbor's testimony is considered secondary to the timestamped metadata of a Ring doorbell or a Nest thermostat. The divorce lawyer now spends a significant portion of their billable hours analyzing the Internet of Bodies. This refers to the data generated by devices that are either worn, ingested, or implanted. If a spouse has a history of substance abuse, a lawyer might argue for a court-ordered wearable that monitors sweat or blood alcohol levels in real time, with the data being fed directly into a legal portal. Case studies from recent 2025 and 2026 filings reveal how deep this surveillance goes. In one landmark case in Texas, a husband's lawyer successfully argued that the wife's smart car data proved a pattern of reckless behavior. By accessing the vehicle's black box, the lawyer could show every instance of speeding, hard braking, and the exact locations where the car was parked during the workday. They correlated this with her workplace badge and data to argue that she was frequently absent from her professional duties, thereby impacting the future valuation of her professional goodwill and her suitability for a shared parenting plan. The car, once a symbol of freedom, became a comprehensive tracking device that documented her every movement for the 2 years leading up to the filing. The role of the divorce lawyer has also expanded into the realm of digital asset management and the protection of virtual identities. In 2026, many American families derive their wealth from digital storefronts, YouTube channels, or intellectual property held in the form of non-fungible tokens or private keys. The lawyer must now be a technician capable of securing these assets before a spouse can transfer them to a hardware wallet or a decentralized exchange. We are seeing a historical trend where the first motion filed in a divorce is often a digital restraining order, intended to freeze access to shared cloud accounts and cryptocurrency wallets. If a lawyer fails to act within the first hour of a filing, a spouse can effectively vanish $1 million estate into a privacy coin with a single click. We must also consider the psychological impact of this total surveillance on the legal process itself. The adversarial nature of divorce is amplified when every argument can be met with a biological receipt. If Sarah claims that John's temper makes the children feel unsafe, her lawyer can now look for spikes in the children's smartwatches that correlate with times John was in the house. This is the weaponization of the human nervous system. The divorce lawyer is no longer just arguing about what happened, they are arguing about how the body reacted to what happened. This level of intimacy in the courtroom has led to a surge in privacy-related litigation, with lawyers now specializing in the defense against intrusive data collection. Step by step, the modern divorce involves a technological audit. First, the lawyer must sweep the client's own devices for spyware or tracking software that a spouse may have installed. Second, they must establish a digital perimeter, changing all passwords and setting up multi-factor authentication that is not linked to shared devices. Third, they must educate the client on the dangers of the Internet of Things, often advising them to disable voice assistants and fitness trackers until the litigation is concluded. This is the new survival guide for the 21st century divorcee. As we look at the data from the last 5 years, it is clear that the divorce lawyer has become a central figure in the debate over data privacy in the United States. The family court is the primary laboratory where the limits of the Fourth Amendment are being tested in a civil context. Does a spouse have a reasonable expectation of privacy in a smart home they share with their accuser? Can a lawyer use a child's data against a parent? These are the questions that define the current legal landscape. But even as the law grapples with the biometric revolution, an even more profound shift is occurring in the way we view the end of a relationship. While Part 8 has focused on the high-tech warfare of the modern courtroom, Part 9 will explore the counter-movement, the rise of the high-end, luxury divorce retreat, and the emergence of the collaborative, holistic lawyer. As the system becomes more automated and intrusive, a new segment of the American public is willing to pay a premium to keep the lawyers, and the algorithms, out of their private lives entirely. What happens when the wealthiest Americans decide that the courtroom is too dangerous for their data? How did the divorce lawyer create a secondary, shadow legal system for the elite that bypasses the public courts altogether? And why is this trend creating a massive divide in how justice is delivered in the United States? The next part of our masterclass explores the world of private judges, non-disclosure agreements, and the multi-million-dollar business of the quiet divorce. We are entering the realm of the invisible legal battle, where the stakes are higher than ever, but the records are burned before they can be filed. As the surveillance of the public court system reached its peak in the mid-2020s, a profound invisible divide began to emerge in the American legal landscape. While the average citizen found their private lives dissected by biometric data and digital metadata in public hearings, the wealthiest tier of the United States population began a mass exodus into a parallel, shadow legal system. For these individuals, the risk of a public record, where every text message, smart home log, and financial indiscretion becomes a permanent part of the civic archive, was an unacceptable cost of doing business. This shift gave birth to the multi-million-dollar industry of the quiet divorce, where the divorce lawyer's primary role shifted from courtroom gladiator to an architect of total invisibility. In this current year of 2026, the elite divorce lawyer is no longer just a legal representative. They are a high-level privacy consultant who operates in a world where the courtroom is a five-star hotel suite and the judge is a private contractor. To understand how this shadow system works, we must look at the mechanics of private judging. Imagine if you are Julian, a venture capitalist in Austin, and your spouse, Claire, is a high-profile tech founder. Their combined net worth is $400 million, much of it tied up in pre-IPO stock, complex intellectual property, and a portfolio of fractionalized real estate assets. In a standard public courtroom, a judge juggling 100 cases a day might not have the time or the specialized knowledge to understand the nuances of a carried interest provision or the valuation of a proprietary AI algorithm. Furthermore, the mandatory financial disclosures required by the state would make their entire portfolio a matter of public record, accessible to competitors, journalists, and bad actors. To prevent this, Julian and Claire's lawyers initiate a private adjudication process. Step by step, the invisible legal battle unfolds with surgical precision. First, both parties sign an ironclad, multi-layered non-disclosure agreement. This NDA is far more restrictive than a standard confidentiality clause. It often includes a non-disparagement agreement and a liquidated damages provision that triggers a massive financial penalty if either party or their staff speaks about the proceedings. Second, they hire a private judge. In 2026, this is usually a retired state or federal justice who bills at a rate of $3,000 to $5,000 an hour. This judge is not a mediator. They are a legally empowered adjudicator whose decisions carry the same weight as a public court ruling, but the hearings take place in a secure, private office rather than a public building. Third, the lawyers stipulate that the final decree filed with the state will be a skeleton document, containing only the bare minimum information required by law to dissolve the marriage, while the actual division of assets is kept in a private, unfiled master settlement agreement. Historical trends show that this move toward privatization is a direct response to the digital exposure discussed in previous eras. As the public court system became more high-tech and transparent, the value of silence increased exponentially. Case studies from recent years in California and Delaware show that nearly 40% of high-net-worth divorces now utilize some form of private judging or binding arbitration. This has created a massive economic divide in the delivery of justice. While the middle class is left to navigate the intrusive world of biometric evidence and AI-driven mediation, the elite are essentially buying their way out of the public square. The divorce lawyer in this sector has become a gatekeeper to a premium tier of privacy, ensuring that the wealth and reputations of the top 1% remain intact even as their families are dismantled. This era also saw the rise of the luxury divorce retreat, a high-stakes evolution of the collaborative law movement. Imagine if Julian and Claire, instead of spending 18 months in litigation, decide to resolve their entire divorce in 72 hours. Their lawyers book a secure ultra-luxury resort in a remote part of the Rocky Mountains. This is not a vacation. It is a high-pressure, goal-oriented negotiation environment. The team includes not just the lead attorneys, but neutral forensic accountants, child development specialists, and even high-performance communication coaches. Historical trends suggest that these intensives have a high rate of success because they remove the posturing and the delays of the traditional legal process. The lawyers use a corporate boardroom model, moving through a preset agenda of asset valuation, debt distribution, and parenting schedules. The potential outcomes of a weekend retreat are often far more creative than a court-ordered split. A lawyer might negotiate a 5-year gradual buyout of a business interest or the creation of a private family foundation to manage the children's long-term educational and medical needs. The financial architecture of these quiet divorces in 2026 is incredibly complex. The lawyer must navigate the valuation of assets that didn't exist a decade ago. We are seeing a surge in cases involving the division of digital personas and social equity. If Julian has a significant following on a professional networking platform that generates millions in consulting leads, is that personal goodwill or a marital asset? The lawyer must hire experts to quantify the value of a digital brand and draft agreements that govern how that brand can be used post-divorce. They are also dealing with the division of decentralized assets, using multi-signature wallets to ensure that cryptocurrency and digital art are held in escrow until the final decree is signed. This requires a level of technical and financial literacy that has fundamentally changed the hiring profile of the top family law firms. However, the growth of the quiet divorce industry has sparked a significant ethical and legal debate in the United States. Critics argue that by allowing the wealthy to bypass the public court system, we are creating a two-tiered society where the law is no longer a shared experience. When a private judge makes a ruling on a complex financial instrument or a novel custody arrangement, that decision does not become part of the public case law. This means that the legal precedents that should be guiding the entire system are being locked away in private files. The divorce lawyer, once an officer of the public court, is increasingly becoming a private consultant for the privileged, further widening the gap between those who can afford privacy and those who cannot. As we look at the data from the mid-2020s, it is clear that the divorce lawyer has successfully commodified discretion. They have realized that in an age of total transparency, silence is the most valuable product they can sell. They have created a system where the end of a marriage is treated like a corporate restructuring, clean, efficient, and entirely confidential. They have mastered the art of burning the records before they can ever be filed, ensuring that for the American elite, the century of the divorce lawyer ends not with a bang or a scandal, but with a quiet, expensive, and perfectly executed disappearance. But as the century of the divorce lawyer draws to a close, we must ask ourselves what remains of the profession. We have seen the transition from the staged hotel raids of the 1930s to the biometric surveillance of the 2020s, and finally to the total privatization of the elite. What is the ultimate legacy of this century-long evolution? How has the divorce lawyer fundamentally altered the American concepts of family, property, and the right to a private life? In the final part of our deep dive masterclass, we will bring all these threads together. We will examine the state of the industry as it prepares for the next century and look at the radical predictions for the year 2050. What happens when the law itself becomes fully automated and the role of the human lawyer disappears entirely? The conclusion to our documentary explores the final frontier of the legal profession and the ultimate fate of the American family in the age of the algorithm. The final chapter of the century is about to be written, and the implications will stay with you long after the video ends. As we stand here in the year 2026, the century-long evolution of the American divorce lawyer has reached its most paradoxical chapter. We have moved from the smoke-filled backrooms of the 1920s to the sterile high-frequency data centers that now determine the fate of the American family. To understand the ultimate legacy of this profession, we must look at the emerging reality of the smart contract marriage and the predictive justice systems that are currently reshaping the legal landscape of the United States. The divorce lawyer is no longer just a representative. They are becoming a code auditor for the most fundamental unit of society. Imagine if you are Liam and Sophia, a couple getting married in 2026. They are not just signing a traditional marriage license. They are entering into a decentralized autonomous marriage, or a DAM. Their prenuptial agreement is not a stack of papers filed in a dusty cabinet, but a line of self-executing code on a private blockchain. Their divorce lawyer acted as a legal architect, helping them program the triggers for the dissolution of their partnership. If specific conditions are met, such as a filing for separation or a sustained period of living apart as verified by location metadata, the smart contract begins a programmatic liquidation of their assets. Their joint bank accounts are split, the title to their digital properties is transferred, and a pre-agreed spousal support payment is automatically routed through a digital currency exchange. This shift toward algorithmic finality is the culmination of a historical trend that began with the move to no-fault divorce in the 1970s. For 50 years, the legal system has been trying to remove human emotion and moral judgment from the process of ending a marriage. In 2026, we are seeing the potential outcomes of this long journey. The divorce lawyer's role has been compressed into the front end of the relationship. They are no longer the scavengers of a broken home. They are the engineers of a graceful exit. Case studies from recent legal tech implementations show that these smart contracts can reduce the duration of a divorce from 18 months to 18 milliseconds. However, this efficiency comes with a profound cost: the loss of judicial discretion. When a machine executes a contract, it does not account for the nuance of human suffering or the unexpected shifts in the economy that we saw during the 2008 crisis. This leads us to the most controversial development of the 2020s, the rise of predictive justice. In courts across the United States, judges and lawyers are now using AI models trained on a century of case law to forecast the likely outcome of a trial before the first motion is even filed. Step by step, the modern legal process has become a battle of data sets. First, the lawyer inputs the client's financial history, the duration of the marriage, and the jurisdiction's historical rulings into a predictive engine. Second, the system generates a probability map, showing a 75% likelihood of a specific alimony award, or a 60% chance of a joint custody arrangement. Third, the opposing counsel does the same. When both sides see the same statistical outcome, the incentive to litigate vanishes. The trial, once the centerpiece of American drama, is being replaced by a settlement generated by a consensus of algorithms. We must analyze the deep impact this has had on the American economy. Over the last century, the divorce lawyer has been a primary driver of the professionalization of the middle class. By fighting for the valuation of professional degrees and the division of retirement accounts, they forced the financial industry to create new products like the QDRO and the insurance-backed alimony bond. Historical trends show that the legal profession essentially created the framework for the modern transfer of wealth between generations. In 1900, wealth was static and tied to land. In 2026, wealth is fluid, digital, and constantly being reallocated through the mechanisms of the family court. The divorce lawyer has been the silent partner in the American consumer economy, ensuring that capital remains in motion even when a family stops moving together. But what is the human legacy of this century? We have seen the divorce lawyer move from the shadows of social taboo to the center of cultural power. They have been the architects of individualism in the United States. By making it legally and financially possible to leave a marriage, they fundamentally changed the concept of the American dream. It shifted from a dream of collective stability to a dream of individual fulfillment. The potential outcomes of this shift are visible in the demographic data of 2026. A record number of single-person households, a surge in the gray divorce rate among seniors, and a generation of children raised in a legal system that treats their time as a divisible asset. As we look toward the year 2050, the predictions for the legal profession are radical. Some legal theorists suggest that the concept of a state-sanctioned marriage will become obsolete, replaced by a series of private, renewable contracts that require a lawyer's audit every 5 years. Others suggest that the biometric data we discussed in earlier parts will become so integrated into the legal system that a divorce will be triggered automatically by a biological mismatch detected by wearable sensors. The divorce lawyer of the future may not even be a human. They may be a personalized AI agent that manages your domestic contracts with the same clinical efficiency that a modern bot manages a stock portfolio. However, even in this high-tech future, the core of the profession remains rooted in the same fundamental human conflict that existed in Reno in 1931. Behind every smart contract, every predictive algorithm, and every billion-dollar settlement is the reality of two people who once promised forever and are now navigating the end. The divorce lawyer, for all their technical evolution, remains the person who walks the client through the valley of the shadow of the law. They are the ones who translate the cold language of the statutes into the reality of a new life. The century of the divorce lawyer has been a century of mapping the human heart onto the legal ledger. We have seen how the profession survived every social revolution, every economic crash, and every technological disruption by becoming indispensable to the way Americans define their lives. They have turned the most private moments of our existence into a sophisticated, multi-billion-dollar industry that governs the flow of assets and the protection of children across the nation. As this documentary concludes, we are left with a final, haunting question. In our quest for a more efficient, data-driven, and objective legal system, have we lost the very thing the law was meant to protect? As the algorithm takes over the role of the advocate, who will be left to speak for the nuances of the human experience that cannot be quantified in a line of code? The century of the divorce lawyer is ending, but the age of autonomous families is just beginning. The legal battles of the next 100 years will be fought in the silicon, but the stakes will remain as high as they were on that Reno train platform 100 years ago. What happens when the machine decides who gets the children? And how will the next generation of lawyers fight for the right to be human in a system that only speaks in data? The story of the American family is still being written, and the next chapter may be the most unpredictable one yet. Keep your eyes on the horizon because the legal revolution is far from over.